conference. For those of you who are celebrating Chinese New Year, Happy New Year, Coming Out Church, all the best to you. I have given out a press statement, also two documents, which is a notice of motion for an application for judicial review, and also an affidavit. So those who have not got the complete set, please come up and get it from Gobind, my political assistant, after this. I'm going to read from my press statement, and then I'll explain to you by referring to the documents that I've given to you. So let's start with the press statement. The DAP has, on the 22nd of January this year, filed an application for judicial review against a decision of the ROS withholding recognition of the re-election of its Central Executive Committee on the 29th of September 2013. Now, on the 20th of December 2013, the DAP wrote to the ROS demanding that it explain under which provision of law it made its decision to withhold recognition of the re-election of its CEC on the 29th of September 2013. The DAP also put the ROS on notice that it would not be bound by any decision which did not have legal basis, and would take the matter to court if necessary. Because the ROS was given 14 days by the DAP to respond to the same demand, the ROS acknowledged receipt of that letter on the 24th of December 2013. On the 8th of January 2014, the DAP again, and this is without prejudice, and in reference to the letter dated 20th of December, wrote to the ROS forwarding to it documents it had requested. The DAP also asked the ROS to provide it with the name and contact number of the investigating officer in charge, so as to enable the DAP to communicate with him directly in respect of the letter. The ROS acknowledged again this letter on the 9th of January 2014. The ROS has not, until the time of filing of this action, officially and in writing responded to these letters. The matter is now fixed for hearing, for leave, at the High Court Kuala Lumpur on the 11th of March 2014. As you are aware, in the application for judicial review, we first need to obtain leave from the court. And it's a two-stage proceeding. After we obtain leave, then, of course, the court will hear the matter proper. I'm also informed that the ROS has now called the DAP for a meeting over the matter, which I'm told is scheduled for this week. And let me say this, notwithstanding the fact that an action has been filed, the DAP will attend this meeting. The DAP again repeats that it always has been and is still fully prepared to assist in any inquiries that the DAP inquiries by the ROS, provided that such is reasonable and in full compliance with law. Now I come to the document entitled Permohonan. This is the application. What we have asked for is an order of certiorari from the High Court to quash the decision of the ROS, as I said earlier, the decision to withhold recognition of the CEC elected on 29 September 2013. We also, following that order, asked for a declaration that decision, of course, is of no effect in law and without legal basis. I have also given you all an affidavit. Now, there are two reasons why I have given you the affidavit. One, of course, the affidavit will set out in detail the complaint that we have made against the ROS. In short, there are two parts to it. Number one, we say that the ROS did not have the power to make the decision that it did. In other words, if you look at the Societies Act, and we say that the Register of Societies derives his powers from that Act. If you look at that Act, there is no such provision which allows the ROS to withhold recognition of a lawfully elected CEC of the DAP. That's the reason why we go to the ROS to ask the ROS to explain under which provision of law they were acting. There's a significance for this, because normally when a decision is made, the party affected by the decision will write to the decision maker and ask under which provision of law that decision was made, because it is from there that the party who is aggrieved will know what his rights of redress are. By pointing out the provision of law under which the decision is taken, then of course the party, like here the DAP, will be able to assess and decide what it is it needs to do therefrom. But of course what has happened here is the ROS has remained silent. It has not given us particulars of the complaint made against us, or the complaint made against the DAP in respect of the 29th re-election. So in other words, absolutely no notice, absolutely no details, absolutely no idea of what it is the complaint is. Whether or not there is a complaint also, we don't know. In addition to that, it has gone on to state that it is withholding recognition of the CEC. And in that letter, it goes on to say that it advised the elected members of the CEC not to make any decision for the DAP until investigations are complete. How long is that going to take? We don't know. So they just write a letter to us and tell us that this is the position and leave it at that. So despite the fact that we have written to them, asking them to explain, no response. Subsequent to that, on the 8th of January, again we write to them. And in this letter, we also provide them with the documents that they have sought. Because earlier when they wrote to us on the 6th of December, they asked us for some documents to assist in investigation. These documents we provided to them. Not only that, we went on further. We asked them, please give us the details of the IO so that we can communicate with him. So it's easier in terms of dealing with whatever complaints or investigation or inquiry that is currently pending. But of course, total silence on part of the ROS. So we are contending that the decision made by the ROS is unreasonable. Because they have now made a decision which has very severe consequences against the DAP. In essence, it paralyzes the DAP because the CEC, which is elected, cannot act on behalf of the DAP according to them. Of course, we think, and it's our position, that they have, of course, no power to make such a decision to begin with. So insofar as we are concerned, we are the rightly and duly elected CEC of the DAP, and the decision taken by the ROS cannot stand alone. We have also alleged mala fides. In other words, we are saying that the action by the ROS smacks of bad faith, because they have not given us details of the provision under which they purportedly acted. They have also not given us details of the complaints. Because they have not given us details of the complaints, of course, we have no opportunity to defend ourselves, because we don't know what the complaints are. We don't know what the complaints are, we cannot respond. If you can't respond, of course, at the end of the day, any decision taken against you when you can't respond cannot stand alone. And on top of that, the letter is open. In other words, it does not state for how long. There is no time frame. They say to you, okay, this is our position, we don't recognize you, you just keep waiting. And when we write to them, they refuse to respond. So insofar as we are concerned, the ROS being a creature of law, in other words, created by statute, the ROS has great powers. The ROS has great powers. It can suspend, it can even dissolve a political party. Great powers at the hand of the ROS. And we say that when there are great powers given to you, then you must act responsibly. If you want to take action against a particular party, this does not apply just to the DAP, it applies to all societies under the Societies Act. If the ROS wants to act, because the ROS has got great power, the ROS must act with greater responsibility. In other words, if the person against whom a decision is taken writes to the ROS and asks for details, offers to assist in investigation, they must reply. They cannot just say, I don't want to talk to you. We have made a decision. You do what you want. We are going to keep quiet. That, as far as we are concerned, is unacceptable. Alright? So as far as we are concerned, we have given them opportunity to answer. Letters have been written. There have been no replies. As a result of which, we have followed through with our suit. Now, the second part of it, of course, is that which relates to letters. Now, in the last few weeks, there have been allegations in the media to the effect that the DAP never sent out a letter to the ROS dated the 20th of December 2013. I'm sure all of you have seen it daily. Now let me say that those reports are blatant lies, with complete disregard for the truth. The DAP sent out a letter dated the 20th of December 2013 to the ROS. This letter is acknowledged by the ROS and it is given to your honor. It is acknowledged by the ROS on the 24th of December 2013. So the ROS cannot dispute or deny receiving this letter. But as I said earlier, and I say again, these people who have made demands which have carried through the press are strangers. Insofar as we are concerned, the purpose behind these demands is to distract us from the real issue at hand, which is the fact that the ROS has not and probably cannot answer our letter of 20th of December. So we will not be swayed by them. As far as we are concerned, we are firm. When we say something, we do it. If I say I have sent a letter, if I say the DAP has sent a letter, then as far as we are concerned, that letter has been sent. I have issued a posting on my blog, if I'm not mistaken, on 15th of January, in which I have said that. I have also said that acknowledgements are with me. And I think the Malaysian Insider also carried a story on this, if I'm not mistaken, on the 14th of January. So as far as the DAP is concerned, we have filed a suit. The matter is now in court. Of course, if the ROS wants to meet us, we will meet them. But in the meanwhile, the suit goes on. Any questions from the press?
The CEC now, the ROC is saying the CE, the central committee that elected, is not, cannot do their work. They're not responsible.
Let me take you to the letter from the ROS. And this is found at Exhibit LGE 5. You got LGE 5? Yes. You will see that there are exhibits. You will look at exhibit LGE 5. You got that? You got it? This is a letter by the ROS dated the 6th of December 2013. That is basically the letter in which the ROS informed us of this decision. The second paragraph, it says, dengan mengambil kira aduan-aduan yang masih diterima dari ketua-ketua cawangan dari DAP yang berurusan hari ini, jabatan masih belum dapat mengiktiraf bahawa pemilihan semula yang telah dijalankan berdasarkan surat jabatan telah dipatuhi. Dan of course, dalam hal ini, Tuan perlu mengungkapkan dokumen-dokumen yang berikut. The senarai is given that was documents to be produced. And overleaf at paragraph 3, dengan ini juga pihak Tuan dinasihati membawa ke perhatian ahli-ahli jawatan kuasa DAP yang belum disahkan kedudukan mereka supaya jangan membuat apa-apa keputusan bagi pihak DAP sehinggalah ROS selesai menjalankan siasatan ke atas pelaksanaan Kongres DAP yang baru berlalu dan pemilihan semula ahli-ahli segitu. Jabatan akan maklumkan keputusan ke atas perkara ini setelah maklumat yang diminta di paragraf 20, paragraf 2 dikemukakan, dan setelah proses siasatan selesai, and so forth. So you can see very clearly that the two parts with one, they say they don't recognize. The withhold recognition of the DAP, the CEC elected on the 29th. In addition to that, there's a caveat placed on all the newly elected CEC members not to make decisions on part of the DAP. How do you operate? How does a political party, how does any organization operate like that? Yeah, insofar as we are concerned, the law is the other way around. The law that governs any society is to be found in the constitution of the society. So the DAP has a constitution. The Constitution provides for mechanisms by which elections are to be held so that its office bearers will be elected. Now, as far as we are concerned, if an election is held pursuant to the Constitution and office bearers are elected, then they are prima facie entitled to credence and recognition until there is basis to decide otherwise. But what is happening here is the other way around. In other words, you have your elections, but we won't recognize you until we are convinced and satisfied after we have conducted investigation. That's the problem. Now that is not how the Societies Act works. Because in the meanwhile, what does the party do? What does the society do? There are daily administrative issues that the DAP has to take. There are decisions which relate to finance or finances of the party which have to be made. There are issues which relate to discipline. I've outlined this in the affidavit. There are also issues which relate to the state committees. For example, the CEC has to appoint or fix dates for the state elections, state committee elections. So how does it work? How does the party just keep completely silent? As far as we are concerned, this order does not make sense, but it is clearly something which is not consistent with or in keeping with the provisions of the Societies Act. Alright? Then of course we have, I'll take you to LGE 6. LGE 6 is the letter that we wrote on the 20th of December. The second paragraph, we say, kami merujuk kepada perainggan 2 dan 3 surat pihak Tuan di mana nyatakan bahawa jabatan pihak Tuan masih belum dapat mengiktirafkan bahawa pemilihan semula telah jalankan DAP pada 29/9/2013 berdasarkan surat Tuan Zam and so forth, dan nasihat Tuan kepada ahli yang kuasa supaya jangan membuat apa-apa keputusan bagi pihak DAP sehingga pihak Tuan selesai siasatan ke atas pelaksanaan Kongres DAP yang baru tersebut dan pemilihan semula ahli isinya dan pihak Tuan memaklumkan keputusan siasatan setelah selesai siasatan tersebut. Jadi sesuai yang saya dengar segala hormatnya, kami sini mohon agar pihak Tuan memberikan kami bukti-bukti aduan atas mananya pihak Tuan sedang siasat pelaksanaan Kongres DAP yang baru sebenarnya katakan. Then of course we ask for particulars in the next paragraph. The following page, we state firmly, kami juga memandang serius kenyataan pihak Tuan di mana pihak Tuan menyatakan tidak mengiktiraf pemilihan semula ahli isi DAP. Ini mempunyai kesan yang luas dan besar kepada DAP. Kami berpendapat bahawa pihak Tuan tiada sebarang kuasa dalam undang-undang untuk membuat keputusan sebegitu, dan kami di sini memohon supaya pihak Tuan memberikan balasan secara tertulis dan menunjukkan daripada mana pihak Tuan mendapat kuasa dalam undang-undang untuk membuat keputusan tersebut. Kami di sini memberikan pihak Tuan notis. Kami di sini memberikan pihak Tuan notis bahawa kami tidak perlu menerima sebarang keputusan dan ada arahan yang tidak didukung oleh undang-undang, dan kami bersedia untuk membawa perkara ke mahkamah untuk diputuskan sekiranya perlu dalam masa terdekat. And the next paragraph very clear, kami memberikan masa 14 hari untuk ROS membalas. So it's very clear that we have responded to their letter, asked them to provide basis, they have failed to do that. And the last letter, of course, last page of the document is the letter where we sent the documents that they have requested. And this was sent as early as 8th of January.
But you're actually seeking for judicial application, you're seeking for such a right to quash the decision of the ROS. Can I say to quash the decision of the ROS?
Yes.
To not recognize the CEC?
I think it's in withholding. It's a matter of language. You're right as well. But the way we have put it in the application is the decision of the ROS to withhold recognition of the CEC, recognition of the CEC elected on the 29th of September 2013. Okay, so are you all okay with that? Any other questions? Okay, if that is all, then thank you very much, Mr. Best, for attending this PC. Once again, happy New Year to all of you. Thank you very much.